Court is now back in session.
Right. We are here on one case this afternoon out of Humphreys County that we're ready for. I think I'd set a review of it under a prior order of this court. Is that correct?
Yes, Your Honor, that's correct.
Your Honor, that's correct. I don't believe that order has been signed at the start of the file, but Ms. Roberts and I have signed off on it.
I hand carried both orders. Your Honor, we were in court on April 26th, and then we were in court on June 23rd. I carried both of those orders and had them and had the clerk and lodged those with the clerk. The second order from June 25th, that Your Honor did not sit on the floor. He signed those. I don't know whether Miss Abby mailed the other.
I've
orders.
signed this order that's in the file, a copy of it attached. If it is, can be treated as the original. If I have not already signed the original, then I've signed this copy, so we're ready to go. And under the terms of that, I made certain findings and certain orders, and that I set it for the matter to come back for review today at 1:30 in the Chancery Court for Houston County, at which time the court would consider expanding the week-to-week schedule that I set during the summer for the school year, a modification of support in any of the provisions of the permanent parenting plan. So that's why we're here today. Either of you wish to make any sort of an opening statement about the situation?
Yes, Your Honor, if I could, as you said, in the hearing that we had back in April 26th, Your Honor found that there had been a significant to a change of circumstances issued all the residential schedule parties. And so you're here to make that determination. What's important for the court to understand, there's been some events that have transpired since that hearing. Number one, Your Honor specifically ordered that the video calls continued between my client and the minor child. My client has placed phone calls each day, and Mrs. Gadd has refused to answer a number of those. Basically, he got about 60%. I've got the exact number, that the number of days that have transpired since the April hearing until today, that she's still not, there's a number of occasions, about 40% of the time, she's refusing to answer the call. She also is sitting beside the daughter during these telephone calls, sitting there, that make it virtually impossible for my client to have just a normal conversation with this child. Additionally, it's our position that Mrs. Gadd, although maybe not to the level of perjury, she certainly misled this court in the previous hearing, specifically dealing with her relationship with her now husband, Mr. Gadd. Shortly after the hearing of this case, there was a domestic disturbance at the home. Mrs. Gadd's husband choked her, slapped her, left scratches and bruises, bloodied her nose, and she had given testimony to, or had made her report to the police officers that this had not been the first time. She reported that her husband suffered from bipolar disorder, and that there had been previous episodes of domestic violence in the home, and that he was medically non-compliant with his medication. Mr. Gadd was arrested and is, I assume, out of the home. But again, this is a situation where Mrs. Gadd certainly did not, she had every opportunity, questioned about her home life. And of course, she led this court to believe, oh, we're in love, we're doing this, he's going to move, and I'm going to go to school here. So obviously that was just disingenuous. And so we'll be questioning her about the extent of that. And there's some other issues about the fact that the minor child there have been some statements during those video calls and other times that the minor child, even though they shouldn't have had any conversation with the child about this, that the minor child has told her, told my client, I don't want to go 7 days, seven days on and 7 days off. I don't want to do that. 7 days is too long for me to be away from my mommy. And so obviously the only way that could be done is either her or her parent, her mother, or if she's still with this Mr. Gadd, is prompting this child to say things. And so again, that just goes to her overall veracity and truthfulness in this matter. And so what we're still asking, Your Honor, is to modify this residential schedule. We would ask, you
You made the finding that there was sufficient to change the residential schedule. You did not change the designation of the primary residential parent. But of course, that's not specifically set out. And then and we still have to do the modification of the residential schedule and the child support. So again, we will have some testimony about the occurrences that happened, and then I'll be calling Mrs. Gadd to the witness stand as a witness on the domestic assault that's apparently been occurring for quite some time in her home.
Spratt?
Your Honor, I don't know how we can make an assumption as to why the child said something, but we would admit this is a 7-year-old child, and the testimony before the court last time was that this child was flourishing, that it was an advanced child. And so for her to say, I don't want to be away from mommy for 7 whole days, I don't know how Ms. Roberts can make the leap to say that she was somehow coached to say that. I'm sure she would love if that were the testimony, but I mean, we'll get to the testimony on that and they can be asked, but I don't think that Mrs. Gadd has coached anybody or been disingenuous with the court. I have asked for this police report from Ms. Roberts. I don't have a copy of it.
The police report that your client filed?
Yes, and I understand, Your Honor, I could have got a copy of that. I do. Mrs. Gadd, we entered an agreed order on Ms. Roberts' motion that Judge Wallace signed where Mr. Gadd would not be around the minor child. We had no issue with that at all. And so there being no testimony, Judge Wallace signed that for us. Mrs. Gadd has filed for divorce and has a hearing, I believe, in front of Your Honor. If that's October 1st. I don't know if that's this court's chancery date in Humphreys County or not, but that is set for a final hearing. They're appearing pro se for a divorce on that. So he is out of the picture. I don't know specifically what Ms. Roberts is saying was disingenuous about that. He does have a mental health diagnosis. We do believe that he was.
What she's saying was disingenuous, if I understood correctly, Mr. Spratt, is the failure to bring to the court's attention any information regarding his bipolar condition, because I made a specific finding in this order from that day that there was no evidence that her present husband presented any problem or any danger to the child, and therefore there was no restrictions placed upon him. So I think that's maybe what she can address that. But.
And she can, Your Honor, and you know, I think I didn't call Mr. Gadd. She made reference to that. Ms. Roberts did during the hearing. I didn't have to call. I can call whoever witness I want to. She could have called and didn't. So I don't know that Mrs. Gadd made any misrepresentations or anything like that towards the court. In any event, he is out of the picture. Mrs. Gadd has, like I said, filed for divorce. And that'll be heard on October 1st. But if we are allowing the child's statements to come in about her not wanting to be away from the mother for 7 days, then I think we should allow it. But what we can't do is make believe that somebody's coached that. If we're going to let that in, then that should be the child's testimony adopted by reference. And we do believe that's how the child feels. The last thing, Your Honor, I don't think a change in primary residential parent, I think the court ruled on that. So I don't think that would be in front of the court today, because the findings that the court made based on the proof at the trial was that the change in circumstances.
I think she's just simply saying I didn't specifically state who was going to be the primary residential parent. She was the primary residential parent under the original order, and I made a finding that there was material evidence of a material change of circumstances sufficient to alter the residential schedule, but not sufficient to change the primary residential parent.
Yes, sir. And
so that matter was ruled upon at that point. And I don't know if Ms. Roberts is attempting to reopen that issue now, or if that's basically what we're doing with it. It seems to me that would be res judicata unless, this is just a review. So, and the order's been down, but whatever, I'll let you both address that.
And since I'm up here.
And Your Honor, just if I could, just the reason that I bring that up is again, I specifically put in the order that Mr. Spratt and I signed, that Your Honor did find that there was a significant, if I could go over it specifically, and I tried to take it. Under the circumstance, let's see, you had found that there was a significant material change in circumstances sufficient to change the residential schedule. What I'm telling you, and then you just said that you were coming to review whether we were going week to week, and then the child support issue. That's what's before the court
Correct.
today. Part of what I want to make sure as far as the record is concerned, it's my position that Mrs. Gadd has been dishonest with this court. So I'm going to question her about that as it relates to this residential schedule and what Your Honor has to reserve. But I wanted the court to understand that you didn't find significant material change of circumstances sufficient to change the designation on that day. So it's my understanding, and what I needed to clarify is that once Your Honor finalizes this ruling, I want to make it clear that I'm using that information as far as the residential schedule is concerned. But it is a significant material change of circumstances since we were in court in April. So I don't want to be foreclosed because I've already prepared a new petition for a modification based on her on that situation. So I just want to make sure that the court's not going to, if the court's going to foreclose me because something happened after the April hearing, and I can't use that as significant material change in circumstances on a new petition, then I do want to ask the court to alter or amend its findings. If I can use that from subsequent, then I'm fine, because Your Honor has ruled that
You are not foreclosed from filing a new petition based on events that occurred after that April hearing.
Yes,
And as far as this court is concerned, any evidence that I hear today needs to relate to the questions that were reserved by that April hearing, which were the week-to-week schedule or whatever the daily schedule would be while the child is enrolled in school, and also the issue of the child support, which is, those are the only two issues, if I recall, that were reserved. Now, as what you're saying, the events that occurred subsequently to it, if they relate to one of those two issues, then you're not foreclosed from raising them, nor are you foreclosed from arguing that in a new petition. But you know, I'll let you all decide how you want to proceed. So,
And briefly on that, Your Honor, if there's a new petition, then we need a new trial. I mean, that's sort of the way
I think everybody agrees with that.
Okay.
But today we're still going forward with those two issues that were before me, or that I reserved for this April hearing. Any issues about if I'm understanding correctly, and I'm not trying to interpret for you, but my understanding, so that I want to make clear that how I understand it, Ms. Roberts is saying these new events that occurred after the April event are, in her opinion, the basis for a material change of circumstances to relitigate the issue of the primary residential parent. And that is a different issue than, as I've already determined, this is only the daily schedule that we're dealing with. The issue of the primary residential parent has already been ruled in this proceeding. So if she files a new petition, there will be a new hearing. Both sides will be given an opportunity to litigate that issue, and the standard will be applied to the higher standard of material change of circumstances.
Yes.
But as we all know, there's a lower standard of proof required to show a material change of circumstances that has occurred that would justify a modification of the daily schedule or week-to-week visitation schedule. And that's what I found earlier in April. So I reserved the modification, if any, of the school year to see how the week-to-week went during the summer and how things were going. And then I also reserved the child support issue so that I could determine the week-to-week schedule during the school year, and then we'll have the modification of the child support, if any. All right.
Thank you.
So with that, then I believe this was your original petition, Ms. Roberts. Is that correct?
Yes, Your Honor, I would call Ms. Gadd.
All right, Ms. Gadd, you're being called as a witness. If you'll come around. You'll raise your right hand and be placed under oath.
You solemnly swear the testimony about the truth, the whole truth, and the truth, so help you
I do. Would you state your name for me, please, ma'am?
Donna, I'm Jean Gadd.
And Ms. Gadd, you recall being in court back in April, correct?
Yes, ma'am.
You and my client, Mr. Coleman, have a daughter. And how old is she?
7.
And since school was out, y'all gone on a week-to-week basis, is that correct?
Correct.
And after you were, one of the reasons that we were coming back into court is you had testified that you had applied and were waiting admission to I think a physician's assistant program, am I remembering correctly?
Correct.
And what is the status of your admission into that physician's assistant program?
It doesn't close till October, so I still don't have official acceptance yet. So
Okay, so you don't know if you're going to school or not?
not in January, but I graduated today with my bachelor's. I'm supposed to have my graduation ceremony today, but I'm here for my daughter instead.
Where did you graduate from?
Austin P.
And you have a bachelor's in what?
Bachelor's of Science in Kinesiology.
And is your application to, I think you said Dyersburg State, is that where you were going? Where were you applying?
I'm applying to multiple PA schools in Nashville and Paris, Tennessee.
Paris, which was the one in Paris?
Bethel.
Bethel. Have you applied to Bethel?
I'm working on the application now.
So my answer to the question is no, I have not.
I have not submitted the application yet. No, it's open to October.
So you've not submitted an application to any place?
No, because it's open till October and I'm doing the PA shadowing hours. I'm getting as many hours as possible to make it look as good as possible. And I've got my letters of recommendation already in. Just racking up as many hours.
You got them in, where have you got them in?
The doctors submit their letters of recommendation to the CASPA application.
Okay,
So I'm at the end of the application process, but I'm still early.
so where are you applying?
Bethel and Paris, Tennessee, Tribeca, Lipscomb, and South College and Meharry in Nashville.
And,
Those are the closest ones.
okay, and again, even though we talked about other things that when you testified in your previous testimony, now you're looking at other areas.
You just have to apply to multiple just in case I don't get into Bethel.
And they all have different schedules.
It's typically Monday through Friday.
And so you'll be going to school Monday through Friday.
Correct.
And then you will be going to, and at some point in time, you'll have to do clinicals.
Correct, but that's usually on the Monday through Friday schedule as well. That's what
Well,
they told me.
If,
And it's all local and I come home that night. That's what the colleges told me.
okay. But you'll be traveling potentially to Nashville or to other areas, Paris, other areas, because there's not any place close at Humphreys County that has a PA school. Is that correct?
For PA school, that's right. I'll be going to Paris or Nashville for PA school. And she'll stay at Lakeview and I'll be the one that travels. But my clinicals are.
They're on down the road.
Well, they're on down the road, but they're local as well. I was promised they're all local. You come home that night. And even DMA where I currently work, they do those.
Since you're no longer in class, have you picked up your hours of work?
Yes,
What are you making? What's your hourly rate now?
still between 30 to 44 hours a week. So now I just focus on work. There's no college until I start a PA school.
And how much is your rate of pay?
$16.50, and then I make 25% more when I work weekends. So whenever I don't have her, I work the weekends I don't have her.
Do you have a paycheck stub with you?
No, I was not told to bring one.
Okay, you
But I can
understood
read
what year
one.
about child support. You didn't bring any proof of your income.
I have it in my phone. I can screenshot it for y'all. Nobody told me to bring it.
Okay. Now, you and your husband are separated.
We've been separated since the event.
Tell us about the event.
So
Objection relevant, Your Honor. And this is again, what you want to get into in her new petition. And
What is the relevance?
Your Honor goes for a truthfulness veracity. Your Honor has to make a determination on setting a residential schedule, which people have been honest, whose testimony you can trust and what you can't. So again, I'm getting into it for the purposes of number one, the environment that the child is in, and was in, and whether or not she testified falsely before the court, because Your Honor relied on her testimony. As Your Honor said, you made a finding specifically in the ruling that there was no indication that either home presented a harm or a threat to the child. And that was the basis of what your ruling was. So now you're making a determination. So getting into when they separated, where he's living, why they separated, what home she's going to be living in, all of that I think is relevant.
Overall, the objection that would be relevant on the issue of the week-to-week schedule that I have to determine for the school year.
So tell me about the incident.
He has not been in the home since New Year's Eve because at that time he stopped taking the medicine for a short period of time, and that was our agreement that he would be controlled with medication if I was with him. So he's not.
I'm sorry, I apologize. Go ahead.
So he's not been in our home because I've been living with my mom since August of last year. So he's not been around Ellie overnight since then. And when he got back on medication again in March and April, he was on it great again. And I came around him from time to time when I didn't have Ellie, but Ellie wasn't around him. Then we got together in May when that happened, and he had been off the medication for 3 weeks. So in May is when he stopped again. And in May, he never once has talked to Ellie, been around Ellie at any point in May. So.
Okay, let me break down this and understand what you're saying. You and your husband have been separated since August of 2023.
That's not what I said.
He moved out of the home in August of 2023 because he was off his medication.
I said he moved out of the home New Year's Eve.
So he quit taking his medication in August.
No, he was taking his medication in August. We were living together at that time. And he was convinced by his family to stop taking it in January. So on that day, I told him, then you're not going to be in the home with us.
Well, why did you say that he's not been in home since New Year's Eve? Because New Year's Eve is December.
I know. So he hasn't been in the home since New Year's Eve, the last day of December.
Okay.
We've kicked him out.
But you said his family didn't tell him to not take his medication until January.
I said he stopped it. He had told me that they were convincing him this wasn't good for your brain. Don't do it. They're uneducated. As far as like medically, they don't have any medical knowledge, and they were making him feel bad. So he told me in December, and I said, the moment you stop taking it, you can't be in the home with us anymore. And so that's what happened. So he was not around us from the first day of him stopping medication.
Why did you tell the judge in the I want you to understand, ma'am, that we had a court reporter and we have a transcript of what you testified to. And do you recall when you testified in front of the judge last time when we asked who was living in your home? Do you remember?
He was living in our home.
Yeah, I asked you on the witness stand who was living in your home. You remember what your answer was? My mother, my husband, me, and my child.
Well, he has not been living
you
in
lied.
the home. I did not lie. I'm
Okay,
not trying to say that I lied.
Sorry. Wait. He left in January, the New Year's Eve, which is December 31st of 2023.
Right, and then
You recall what
started-
day we were in court?
That's,
He
witness
started-
be allowed to answer.
he
Well,
started
she
taking
had-
medication again in February.
Hold on
January,
just a
March,
second.
and April.
Everybody stop talking. Mr. Spratt has an objection, and your objection is,
That she be allowed to answer. It's a compound question, Your Honor.
well, it was a compound question, so that would be inappropriate. Well, actually, she never got around to the second part of her question. She was saying that I believe she said that he was left on New Year's Eve. Do you recall what day we were in court? And that was before she got, and then your client started answering it. So I'm going to overrule the objection. Ms. Roberts, please state a very concise,
Yes.
restate your question concisely. And ma'am, if you'll listen to that and just answer the question, and then you'll be allowed to explain it if your lawyer will let you, if she doesn't. So.
Ms. Gadd, you have just testified, first of all, something about August, but then you moved on and said that he has not lived in your home since New Year's Eve, which is, for the record, December 31st of 2023. Is that true?
December 31st. Yes, he hasn't lived. I said we moved back in with my mom in August 2023. So he was living with me and my mom and Ellie at Linda Hill's house in New Johnsonville from August, from our apartment we had in Dixon. It's when we moved in with mom. He left the home December 31st.
Okay. And so you recall what day we were in court on this hearing?
April 26th
Of what year?
of 24.
And you remember you testified that Mr. Gadd was living at your home with your mother and Ellen. You recall that testimony?
I don't technically recall saying he lived with us, so I may have been confused by the question because my mom's here to testify he was not living with us, but he had been back on medication, so we were still together and I would see him, but he didn't live with us at that time.
Where was he
until I made
living?
Sure, with his family in Antioch, where he currently lives.
How many occasions was Mr. Gadd present when Mr. Coleman come pick up his daughter? Between New Year's Eve and when we were in court in April.
Maybe he saw him with me if we were hanging out, but he had not lived with us.
Have you spent the night?
No, he has not spent the night with us. I was making sure he stayed medicated that time because I take that very seriously.
But wasn't he going to medical school?
He was going to be a chiropractor
Okay. So he's got some medical knowledge, but he voluntarily quit taking his meds.
because of his family, and he regrets that.
Okay.
But that's why he was back on it. He only was
And
off of it in January and went back
Okay.
February.
How do you know he regrets it?
Because he said he regretted it.
So you've been in communication with him, haven't you?
No, in front of the judge when I was there.
Whether she's communicating with her husband, we're here for the child. We're going way out of this residential schedule.
We are absolutely here for the child. I agree.
So the objection is to relevance, sustain the objection.
So it's your testimony that Ellie has had no contact with this man
100%.
from when to when? And again, I want to caution you. You understand Zoom calls are recorded.
Okay.
Okay, so with that understanding, from December 31st of 2023 until today, how many times has Ellie been around?
And not relevant, the relevant time.
I'll move on, Judge. I'll move on.
Ms. Roberts is moving on. Sustain the objection.
Have you filed for divorce?
Absolutely.
When did you file?
I had to file yesterday because he was in Egypt on a planned vacation, so I couldn't be able to file while he was out. And then when he came back, the Waverly Chancery Court, one of them's been sick for a week, and then one of them was on vacation for a week. So that was the soonest day I could get it in.
They've been open every day.
Okay, ask him.
Her testifying, Your Honor.
Why did you have to wait for him to be out in the country?
A signature and notary.
So did you meet him to get it notarized?
No, I left it and he mailed it to him and he went and got it done in Nashville and then sent it back to me.
So you mailed it to him.
I mailed it to him.
You stated that this incident in May was not the first time he had been physically abusive to you. Isn't that correct?
That's not what I was telling the cops that day. That's what you got wrong. I said this wasn't the first time he stopped medication, which is what I testified today.
Have you testified? Have you had a preliminary hearing?
That's set for October. So no, he's never beat me, never hit me like that before.
Like that before?
He had never, that he had been off the meds before, which is when we separated. But he's never beat me before.
What are your work hours now, ma'am?
8 to 3:30, sometimes 8 to 5.
Full time? You said
Yes.
between 30 and 44 hours.
Mhm.
And that will continue through at least when?
Until January at least. We have to wait to know the PA school.
When does your daughter start school?
She started Thursday.
Have you allowed the Zoom calls?
Yes. He's gotten what the divorce papers say, at least 2 a week. He's always gotten at least 4.
He's called multiple times and you've refused to answer, isn't that correct?
Has he gotten all at
I
least
didn't
2 a
ask
week?
you, listen to my question and answer it, please. Your Honor, could I instruct the court to tell Ms. Gadd to listen to the question and answer my question rather than
As I had,
gratuitously?
I said before, just listen to a question, answer that question. If there needs to be an explanation, Mr. Spratt will give you a chance to explain it.
So Mr. Gadd has called a number of times that you refused to answer, is that correct?
No.
Have you seen where he's called and not returned his call? And again, I caution you to understand that we can subpoena your cell phone records.
Okay.
Okay, so it's your testimony that you have not seen where he's called and you missed a call.
You're saying I haven't seen a missed call and had Ellie return
Mhm.
back a call?
Right.
Ellie's always either text back or called back, yeah.
So each time that it's your testimony here again under oath, that each time that Mr. Gadd is called, if you've not been available, is there something funny? Here, there he is. Could you tell us what's funny?
Mr. Gadd?
Oh, I'm sorry. There we go. Mr. Coleman, good deal. Thank you. Thank you, ma'am. Mr. Coleman has called, had his FaceTime calls, and have there been occasions you've missed those calls?
There's only been a handful of calls where she didn't answer. We were in the middle of something, but usually she calls back or she texts, just like he texts sometimes instead of calls.
But is it usually or is it all the time? Because again, see, you're
Not
talking.
all the time.
She all the time texts or calls back. Is that your testimony?
95% of the time, there's a communication with her that day. All I know is I followed the divorce papers.
So at the point in time, and again, Mr. Spratt may object to this, so let me finish my question and let him have an opportunity. You recall testifying that during the hearing the last time, that your husband was applying to schools outside of Tennessee and that you never indicated that y'all weren't living together or that he was off his medication, did you?
At that moment, he wasn't off the medication. Because like I said, he had started back again for several months. So me and him were married and not living together, but we were okay on good terms. But no, he's still applying and he's accepted into Logan University, and he starts either September or January. I don't know which one he's chosen now because we haven't been in communication for 2 months, except for the divorce papers like the judge ruled.
Have you told Ellie that the judge is considering going week to week?
I haven't told Ellie that.
She hasn't over Zoom calls while do you sit there during the Zoom calls?
I do the same thing he does, is we're walking around doing stuff in the house and hear it because it's a video call. So I hear what they talk about and he hears what we talk about.
I believe that's all.
Mr. Spratt, you have questions?
Yes, Your Honor, thank you. This, yeah, just briefly, was Ellie around when this incident occurred?
Not
With you and your
anywhere
husband?
close. No,
He was nowhere close.
no.
Okay, so in your testimony, there were some things I heard and didn't hear. You're saying that he left the home on New Year's Eve of 2023,
Yes, sir.
and then he came back or was allowed to come back for a period of time when he was medically compliant with his medicines. Is that right?
He was allowed to be around us while he
Around,
was
that's what I
medically
meant.
compliant, but we didn't allow him to move back in until I knew that he was going to stay on it and there was no interruption to the medication.
Okay.
So
And-
he went out with us and she saw him out in public, but he was never back in the home in Mom's driveway.
And this incident, this domestic assault, this happened when
The domestic assault was May 20th
of this year?
of this year.
Okay. And did you, there are bond conditions in place, right?
Yes,
And you're not under any restrictions whether you can talk to him or not, right?
I was allowed to talk to him for concerning the divorce.
Okay.
But
Hey,
we're,
but that's what he's allowed, right?
Mhm.
You can't get in trouble for talking to him, right?
right,
Okay. And but you did agree to an order where he wouldn't be around the child, right?
of course.
Okay. We didn't even have a hearing on that, did
No,
we?
because that was what I intended to. I've always kept Ellie safe and there's never been a single day where she wasn't safe,
And now you're gonna divorce him.
of course.
Now, throughout this child's life, have you done the majority of the primary caregiving?
Yes,
Okay. And tell us again, did she have a hard time with going, did she express to you that she had a hard time staying a full 7 days during the summer?
That was
I'm gonna
hers.
object, is Mr. Spratt said clearly the child statements of hearsay.
Would appear to be hearsay, Mr. Spratt, sustain the objection.
Okay. And you said the child has started in Lakeview, is that right?
Lakeview.
Okay. And has she been in Lakeview? She's been in Lakeview for a while.
She was there
Couple
for
years.
first grade as well.
Okay. And she's done well at Lakeview.
She loves Lakeview,
Okay. And you live in New Johnsonville, right?
3 minutes away from Lakeview.
Okay. She had friends there at school?
Yes, which she played with while I had her during the summer. She got to play with her girlfriends that she had during the summer under my care.
Now, I want to get something clear on the income. Were you saying 30 to 44 hours or 30 to 40 hours? That's what I couldn't hear there.
It's usually 30 to 40. I've only one time this year worked 44 hours in 1 week.
Okay. So an average of 35 hours, would that be fair?
Sure.
And you're in the process of putting in these applications for kinesiology school
For PA school, correct?
or PA school?
Mhm.
Those are my questions, John.
Roberts, any redirect for this witness?
May 11th, you remember the Zoom call then?
Jake,
Not
that's outside the scope of cross.
It hadn't had any conversation. Your Honor, it goes to the point of that Mr. Gadd, he asked about, Mr. Gadd had not been around the child. I believe that is coming up in the testimony about him. And we have a recording showing Mr. Gadd with the child on the tape.
Well, I'm going to sustain the objection because it's outside the direct what he said, but certainly your client can, if I understand correctly, it's a Zoom call between him and the child. And
Now, well, a Zoom call between him and his child.
in
Mr. Gadd's
that
been home.
Zoom call, the individual was there. And it was established if whether she answers it or not, it obviously goes to her credibility. So,
And we'll say that for the grand jury for.
all right. Thank you, ma'am. You may step down. Mr. Roberts, you may call your next witness.
Your Honor, I'll call Mr. Coleman.
Come up, Mr. Coleman. I'm going to ask you to raise your right hand and be placed under oath.
Solemnly swear the testimony about to give the truth, whole truth, and nothing but the truth, so help me God.
I do.
Your Honor, I believe, I don't know that I did, but I believe I submitted an income expense statement at the time of the last hearing. Is that an exhibit? If not, I'll do it again.
Well, let me look for it. What are you?
It'd probably be just as easy for me to do it again. That's fine, Judge.
Okay.
Mr. Gadd, you still
I do
in?
have it right here.
Oh, you do, okay. Could you tell me the reference number?
Exhibit 1 from the April 26th hearing.
And just make it two. Mr. Gadd, I'm gonna show you a document that we made an exhibit 1 to your testimony the last time we were in court. I said, I can tell you, I am so sorry. Mr. Coleman.
Yes, ma'am.
Okay, I apologize. Mr. Coleman, we made this an exhibit to your testimony, and are you still employed?
Yes, ma'am.
And again, just refresh the court's memory as to what you do.
I'm a vendor for Frito-Lay.
Okay, and what hours do you keep?
I work for regular big business hours during regular typical store
Monday through
business.
Friday, 8 to 5?
Yes, basically.
And you have the availability to alter your hours and to drop your daughter off and pick your daughter up and do things such as that?
Yes, ma'am.
And you testified to that, and that test from the previous hearing, and that testimony is still true and accurate.
Yes, ma'am.
Nothing's changed as far as your employment is concerned.
Nothing's changed.
Yeah, I'll rephrase. Has anything,
Object to the leading.
I'll rephrase it. I was just trying to get foundational judgment. Has anything changed with your employment, Mr. Gadd? I did it again, Mr. Coleman.
Nothing has changed.
Okay. Has anything changed with your living situation?
No, ma'am.
Are you able to carry your daughter to school and pick her up and have caregiving if you're not available? Do you have other family members there to do it?
Yes, ma'am.
And who are those family members?
Primarily, well, really just my mom, my mother.
And she's here in the courtroom today. And what is her name?
Sheila Coleman.
And where does Miss Sheila live?
She lives in Waverly.
And is she available if you're on a delivery or doing something to be able to pick up Ellie or to drop her off?
Yes, ma'am.
How is your residential time during the summer gone?
It's been amazing. We had a vacation and had several outings, just fun outings with her, whether it be skating. She's taking up skating now. Regular trips to the park.
And just staying at home on a regular day.
Yes, ma'am.
Okay, go grocery shopping,
Yes.
do
Yes,
the
ma'am.
laundry,
Yes, ma'am.
get up in the morning and have breakfast,
Yes, ma'am.
and just do everything normal.
Yes.
How has she acclimated?
I think she's acclimated well. Yeah, I think she's acclimated well. There's been she has stated some things that were troubling.
Object to hearsay, Your Honor.
He's not said
He hasn't
anything.
said anything yet, so I'll sustain it as to hearsay if he were to attempt to say anything.
Have you made an effort to try to communicate and get along with Miss Gadd?
Always.
Okay. Has that been forthcoming from her?
No, not at all.
Can you give us an instance?
Really, it's just been, she's always trying to instigate something, trying to, whether it be throwing insults, like she does those things with regularity.
Give
And
me an example of it, just throwing some shade, if we would.
now, does it need to be specifically after first hearing?
Yeah,
Okay.
the judge ordered y'all in the order to get along, he went painstakingly and told you that your daughter has unlimited potential if y'all will just get over yourselves, basically. So have you made an effort to try to be congenial and to work out so you can co-parent with your daughter?
Always.
And has she done that?
Nowhere near as much, no.
Has it changed since the last hearing?
No, as far as how she's conducted herself, no.
Have there any specific instances that you can tell the court that has gone on since that time?
Well, there's still talks of just, still talks of just how much they miss each other. And one of the things that's also troubling is whenever she talks about, like, I'll have Ellie and she will put it in her head how many days it is until she gets to see her. It
Your Honor,
goes into hours.
Your Honor, object to the basis of knowledge of lay a foundation for how he knows what's in the child's head, or how he knows that this
I'll
dad.
lay a foundation.
Well, let's allow her to lay the foundation. We'll reserve your objection till then.
Does Miss Gadd have Zoom calls, have FaceTime calls with Ellie when you've got her?
Every time.
Okay.
Yes.
And during those FaceTime calls, are you in and around the area?
I mean, I may be, but I'm maybe doing chores or something, but I'm not. I mean, I let them freely talk.
Have you had an occasion to overhear Mrs. Gadd during those calls?
Yes, ma'am.
And tell me, has Mrs. Gadd ever made reference to how long it's time before Ellie comes back to her?
Yes, ma'am.
Okay. How
Yes, ma'am.
often is that?
Wow. Almost every time.
And seeing your daughter, prior to calling and having communication with your daughter, does your daughter appear to be in distress or anything, or is she just enjoying herself?
Like during the call?
No, before, like y'all are out doing
Before,
stuff and then mama's on the phone. What
Yes,
happens?
before the call. Yes, or
Ring.
before the call, she's having fun. I'm like, kid.
Ring, ring, ring. I'm with your mama. Here you go. Talk back and forth. Then what?
So after the talk, there has been times when she's frustrated and she's trying to think of the time. That was specifically the time when she mentioned
Don't say what your daughter said,
Oh, okay.
but just how does she,
How does she act?
is she sullen? Is she withdrawn? Is she angry, sad? What?
Yes, yes, she has been withdrawn sometimes on occasion.
When you make FaceTime calls and things, do you try to guilt trip your daughter?
Oh, never.
Talk about, oh, you only have to stay with mama so many more days?
Never. And if I have to, if I have nothing to say, I'll just play a game with it, because on a Zoom call, you can play little video games. I'll just do that. Don't even have to talk much, I just want to have contact with my daughter and continue the connection.
And did Mrs. Gadd, during this period of time, and again, it can be before and after, did you ever know that she and her husband are separated?
That in 2023, I think it was the summer, he was not around as much. And
You heard her testify that in April, he was not living there.
yeah,
I object to the relevance again, Your Honor. This is a fishing expedition. Clearly, Ms. Roberts is going to file a petition, let her file a petition. But she's trying to she's going on a fishing expedition for that petition. It's not relevant.
After, and again, I'm going to make it relevant, Your Honor.
Well, I'll reserve ruling until it's made relevant.
So prior to the hearing and on the day of the hearing, were you aware that Mr. Gadd was not living in that home?
no,
After that hearing, you heard her say he's not been there and not only been around Ellie in public. Had there been was there a Zoom call that he was present on when you called your daughter?
absolutely.
And was that May 11th?
It was May 11th.
And where was your daughter with that Zoom call?
So my daughter was, they went to a chiropractic appointment, and she was in, I think it was Spring Hill, Tennessee. Her chiropractor's name is Dr. Miles Sautebean, something like that. Yeah. I called at around 7 p.m. that day, so the day before Mother's Day, and she was playing on a playground. And specifically, she was on something that she wanted me to, watch her do, play. And he spoke to her, like he was like, "Oh, Ellie," and I don't exactly know what he said, but it was him. It was the accent, and even Ellie told me.
Okay.
Yeah.
Object to the hearsay and object to the foundation. Again, he didn't even know who was talking on that phone call. I think it was his testimony.
It's not what he said. He did.
He said it sounded like him, so he didn't identify him.
Well, he said his accent and that he called the child by name. That goes to the weight, not to the admissibility. We'll rule that part.
But that was that was in public.
Yes.
Okay. Were there ever an occasion after the hearing that you went to the home to pick up Ellie and that he was there?
I haven't been going to the home, so
Where have y'all been meeting?
in Dollar General in New Johnsonville.
And he said he accompanied her on any occasion when you exchanged Ellie.
Right before the hearing.
Right, but since the hearing, he has not.
No.
You want to go week to week with your daughter?
Absolutely.
I believe that's all. Thank you, sir. Now he's gonna have some questions.
Afternoon, Mr. Coleman.
After me.
You said, Ms. Roberts said that you heard, and you did hear Ms. Gadd's testimony today here, right?
Yes, sir.
Okay, and what she said was that since the domestic that she had, that Elliot had no contact with or with your daughter. I mean, with Mr. Gadd, since the domestic.
Yes, since the domestic.
Okay, and that happened on May the 20th, didn't it?
Yes.
Okay, so this May 11th phone call, whoever was on there with the accent, her testimony was truthful in that regard, right? That was before May the 20th, right? May 11th comes before May 20th, right?
Yes.
Okay. So she's taken every step she needed to take to make sure that he doesn't have contact with her, as far as you know.
Objection, I'm overly broad and assuming my client doesn't know what steps Mrs. Gadd has made.
Sustained, I think it's speculative and potentially argumentative, because you're asking him to state as a fact that she's taken every step possible, and he would have no basis for that knowledge necessarily.
Yes, sir. Do you know, so you know of no times that Mr. Gadd has had contact since what you say you thought you heard on May the 11th on the phone call. You know of no times that Mr. Gadd has had contact with Ellie since then, do you?
No, I don't know,
That's what,
not since the hearing essentially, right? Since,
sure, well, I mean, I believe your testimony was May 11th.
well, May 11th, yeah, May 11th, because we're, yeah, May 11th is that's, yeah.
Okay.
Yeah, that's fine.
Okay. And you say that you overheard my client on the Zoom calls talking to your daughter about, how did you say she put it?
On May 11th?
No.
Oh,
just in
you're talking
general.
about just in general?
Yes, sir.
I mean, they, again, this, you know, they continue to talk about how much they miss each other, how, you know, how many days they have left till they see each other.
Her and her daughter, right?
Yes.
Okay. And so you don't know who's initiating that, whether it's Ellie or whether it's Alma then?
No, it's usually them. Usually them. Usually Miss Gadd.
But you didn't testify to that earlier. You just said you heard your daughter saying it. You didn't know who initiated that, or at least you didn't answer it when you were asked by Ms. Roberts. So you don't know specifically whether or not the child just misses her mom.
Well, I mean, I know she misses her mom,
Okay.
but this continued conversation about and being dismissive about my time with my daughter and just can't wait to, you know, till they can reunite, like it's inappropriate.
In your opinion, right?
I mean, there's professionals that talk about those type of things.
Well, you miss your daughter when she has her, right?
Absolutely.
So what is inappropriate about your daughter missing her mom?
Well, it's just the dismissive, professionals, myself, I find it's disrespectful to be dismissive of the other parent. Matter of fact, they can never say that I don't even say, like, of course I miss my daughter, but I'm respectful of their time. Yes, I do call every day and I want to speak with my daughter, you know, even if just for 5 minutes, just to have just a little contact with her. I do that every day, you know, but I'm not doing anything that, you know, that I feel is disrespectful of their time or not honoring of the fact of her title, you know, her and her grandma, you know.
And what happens if Ellie says she misses you on a phone call? What do you say?
Actually, to be honest with you, I don't think it happened. I can't recall a time where that's ever happened because I've set the tone with that. I have completely set the tone to not say that to my daughter, not because I don't miss her. I'll tell her.
Sir, I'm asking you, if she asks you if she misses you, what do you say? How are you gonna deal with it? Are you gonna,
Well,
if the daughter
I mean,
asks you, says, I miss you, Dad, how many days
if
till I see you?
okay, if it comes up, of course I'll tell her I miss her, but I'm moving on.
Are you gonna tell her how many days it is till you,
Absolutely not.
you're not just gonna cut her off right there? That's how you handle that.
I'll tell her I miss her, move on and go to a different subject. I'm not going to go into this, you know, beat down how much we miss each other. I'm not going to do that.
So in your opinion, she should show less affection on the phone calls.
You can show affection, but I think there's a way that you can go about being respectful of the other parent's time.
Tell me about your work schedule. Are there times when you go to work at 1 o'clock in the morning? What have you got there?
Absolutely not. Oh, it's the expense report.
Okay, I'm sorry. I didn't know if it was notes or what it was, Your Honor. Are you moving?
It already is. I handed it to him because my records to exhibit 1 is I asked Judge Wolfe earlier, so he would have to, that was the one. If it was saying that happened, it was in
You go to work sometimes at 1 o'clock in the morning?
No.
You never go to work? What's the earliest you go to work?
The earliest about 6.
The
5
earliest,
5.
5.
Yes,
Okay, that's the earliest you've been to work since April 26th until now.
that's when I
5
clock
p.m.
in.
That's when you clock in. You're never there earlier.
I mean, I think so what I do is when I have her, I actually start later to make sure that, you know, she gets more sleep in. So as far as with her, 5 o'clock is the earliest.
So when you have her, you go to work at 5 o'clock in the morning.
Yes, with her, 5 o'clock is the earliest. But by myself, yes, I'll go in earlier sometimes.
Okay, what do you do with her at 5 o'clock in the morning?
I'll take her to my grandma's house, or
To your
I'm sorry,
mom's house?
to my mom's house.
Okay. And your mom, so you take her, you have to be at work at 5 o'clock in the morning, right?
I
Almost
really,
there.
well, that's the thing. I can shift my schedule. You know, I can make it later. But yes, 5.
Okay. And you live in Camden
Yes,
and your mom lives in Waverly, right?
yes,
Up on the hill there on Highway 13, is that where we're talking about, up above the viaduct? Is that right?
yes.
Okay. And so you leave, if you gotta be at work at 5 o'clock in the morning, what time do you leave your house in Camden?
About 4:30.
Okay, so you wake the child up, right?
Yes,
And take her all the way to Waverly,
yes.
and then your mom has to take her back to Johnsonville, right?
No,
To school.
no, actually, I take her. There's not one time that my mom has taken her to New Johnsonville School. Not one time.
Or do you go to work and then leave again and come back to Waverly and get her and then take her back to New Johnsonville?
Yes, I do. And then I'll
You
pick
do
her up.
that.
Yes.
That's what you're gonna do. You're gonna clock in. Where's your work at?
Frito-Lay.
Where at?
I mean, it's in
What city?
Waverly. For very.
So you're dropping her off at your mom's house. You're gonna leave work again and then take her all the way back to New Johnsonville
Yes, then I come back.
and wake her up at
And-
4:30 in the morning just to do that.
Well, yeah, I mean, I start my work. Yeah. Pick her up from my mom's house, take her to New Johnsonville, take her to school, and then I'll make my way back to Waverly and finish out my route.
But you leave and you have to be at work at 5 a.m. So you take her to your mom's first, right?
Yes, yes,
Okay, and so then you leave there, you're clocking in at 5 a.m., right?
yes, yes,
All right, and then you're leaving work and going back to your mother's house, right? To
yes,
pick her up
yes.
and then take her to New Johnsonville to
Yes.
school.
Mhm.
Okay,
Yes.
all right. And you have to wake her up at 4:30 in the morning to do all that, right?
Yes,
Okay. And if she was 3 minutes away, if you lived 3 minutes away, that'd be a lot more convenient, wouldn't it? For school purposes, wouldn't it?
yes,
Okay. And Ms. Gadd lives 3 minutes away from Lakeview School, doesn't she?
yes.
Okay. All right, and you testified before that you had never, is there any nights that Ellie stays overnight with your mom
I mean, by,
without you there?
not without me.
It's
No.
never happened, right?
Your Honor, again, I'm gonna object. Are we talking about since April? I mean, again,
We're talking about, I'm sorry, go
again, I object because again, we're talking about since April or before.
on.
He's using the word, has Ellie ever spent the night with her grandmother? Ever. The child's 7 years of age, so again, relevance to an ever, and ask it.
Just state your question, and limit,
Your Honor, if I may-
notify the time.
Particularly if I can respond to the objection, what I'm doing is going over his disingenuous testimony, just like she's trying to do with him. He testified at the previous hearing that that the child had never stayed the night without him present at his mother's house.
Again, I'd like to see the transcript of that, Your Honor. I object to that.
I can move on. I can move on. I can just.
Brad is moving on.
Okay, so to sum it up, and you've had a good time with your child this summer, right?
Absolutely.
Okay, and that's been good. You've got to do things like that, right?
Yes,
Okay. And your work schedule, you have to uproot the child during school at 4:30 in the morning and take her past where she goes to school. And then you have to leave work again and come back and take her back to school.
yes,
Okay. And the child misses the mother, it's for 7 days at a time. You don't disagree with that, right? I mean, that's
I
what
mean-
we're talking about with the phone calls.
Again, Your Honor, I'm gonna object as to the form of the question. My client has testified that after the mother's prompting, she will say, I miss you, and how many days it is. Him making them think the child misses her mother during the 7 days, I don't think he can, that's cause for speculation and opinion that he can't.
He never testified who initiated all that. So, I mean, I think we agree, not every time. He couldn't
Are
answer.
you asking the question about, for this witness to testify that in his opinion, his daughter misses his mother for 7 days in a year, in a week, or that you're
Yes.
saying that she's away from her mother for 7 days a week? Do you understand the distinction? If you're asking him, and under the circumstance, she would be away from her mother, the missing, the use of the term missing carries with it emotional baggage that the child is feeling about being away from her mother, missing her mother. And that's different than just being apart from her mother, which is clear if it's a week on, week off. That goes without saying. So what are you asking him to testify to?
That the child, whether or not the child expresses, and we've already gotten into that, whether or not the child expresses that she misses her mother. All I'm asking, all I was doing was going back about the testimony, what I believe he
I thought there
testified.
was an objection to quoting what the child said that was sustained by the court.
There was, and then they got into it and I didn't object.
They actually didn't get into quoting the child. They got into statements made by your client allegedly that while he was with the child, that she would say things, I miss you, and it's only so many days until you're back with me, and that sort of thing. That's the way I understood the proof. Now, I did not hear them ask him on direct as to whether or not the child expresses the fact that she misses her mom and wants to go home to her mom.
Yes, sir. And what I was asking specifically to go back over, it wasn't necessarily during Mrs. Roberts' direct, is that he didn't know who initiated those back and forths between the mother and the child, whether it was the child or whether it was
All
because.
right, well, I'm sustaining the objection to the form of the question that you had asked him because you're asking him to relate what the child would say in the form of missing her mother. It doesn't surprise me if the child is with the father and says, I miss my mommy, or telling mommy, I miss you, or when she's with the mother, that she would miss her father. That doesn't surprise me. You've got two parents who are, both love their daughter and unfortunately can't be together. So this child is going to grow up having to be swapped back and forth between these two parents. The child is going to suffer. There's no question about it. She's going to miss her mother when she's with her father. She's going to miss her father when she's with her mother. That is the nature of a divorce with children and the custody of children. So how they treat that situation, how they interact, whether they do something to exacerbate that and make it worse on the child emotionally, or whether they try to aid the child in dealing with the harsh reality of the fact that their parents can't live together. That is the question, whether they do something to comfort the child and to reassure the child without making her emotional baggage worse. That is what I am determining in this particular situation, not whether the child misses. I know the child misses her mom when she's with her dad and misses her dad when she's with her mom. I would be shocked if she didn't.
Thanks, Ron. You have not heard all those conversations though, have you?
I mean, I've heard a lot of them. I won't say it's 100% on it either way,
Right.
but it's
And
a
I'm-
long.
I'm just asking yes or no. You've not heard them all, have you?
No, I guess not 100%.
So then you can't say what Mrs. Gadd has or hasn't done to reassure the child.
I
Without hearing
mean,
those all.
now specifically Zoom calls or video calls.
Yes, sir.
I
Have
mean,
you heard them all
I
or
guess I
not?
can. I mean, I'm not sitting right beside her the whole time. I mean, I'm moving around doing chores or whatever. I'm not just sitting there. I mean, not every, I don't do that. I give her the freedom to speak, but I hear both sides. I've heard these things. I mean, that is a fact.
But you haven't heard all of it.
I
You
mean,
just said sir, it's a yes or no. Have you
I
heard
mean-
it all or not?
I mean, I guess I can't say I've heard 100% all of it. No.
Okay, that's my question. And those are my questions. Thank you.
Redirect.
Ms. Gadd, have you ever heard, Mr. Coleman, have you ever heard Mrs. Gadd initiate conversations with y'all's daughter wherein she is talking about how much she misses Ellie?
Yes,
Have you heard Ellie initiate during conversation? Has Ellie made comments?
Objective hearsay.
I'll
Sustain the objection.
I'll move on. And how does Ellie react when her mother does that?
when she does that, I mean, she starts to, the happy mood starts to, it's heavy on her emotionally. You can tell it. You can see it in her face. I hear it in her voice.
Now, do you go to work and you have stated, and again, I want to clarify for this court. Do you go to work every day at 5 a.m.?
Yes, I mean, again, I adjust my schedule to give her more time, but yes, just.
Well, it either is, I don't understand, again, I want you to explain to the court,
Okay.
because saying, I adjust my schedule makes absolutely no sense.
Okay, when I don't have my daughter, I go
Yes.
to work early.
Okay,
You know, when I do have her, I scale it back to give her more time.
scale what back?
My start time,
And what is your start time when you have Ellie?
5.
Do you have to be in Waverly at 5
Uh,
to clock in?
I don't have to be.
Okay. So what time do you get up? When Ellie's with you, Ellie's going to school. In your previous testimony, when we were in court in April, when we were asking for this modification,
Yes,
you testified that you could adjust your schedule so that you could drop Ellie off at school.
yes,
So I want you to explain to the judge what that means. Are y'all gonna be at home in bed and get up and you drive her to school and then go start to work? Are you getting her up early, carrying her to her mother's, letting her lay back down, you go work some, come back and pick her up? What does that
Yes.
mean?
yes. So, okay, so I will get her up 4:30, start my work day at 5. Now I will drop her off at my mother's house on my way to work. Let her sleep, get another hour or two sleep in or whatever. Then in the meantime, while she's resting, I'll start my work. I'll start my work. Then I come back to pick her up from my mom's house
At what time?
at 7. At 7. Because I can get her there in New Johnsonville as early as 7:20. So I take her to New Johnsonville school, then I make my way back to Waverly, finish my work, and then I pick her up at 3 o'clock
At school.
at school.
And then what do
Yes.
you do?
And then we go about the rest of our day.
You don't have to go, you're done by 3. You're done when you pick her up from work.
Yes,
Okay. And then y'all spend the afternoon together and do things as a family.
yes,
You fix dinner.
yes.
Objection outside the scope of cross.
Sustained.
You have just a normal afternoon.
Yes, ma'am.
Okay. That's all. Thank you.
Mr. Spratt?
Briefly, Your Honor. So your testimony at the hearing in April 26th had, you completely left out the fact that you were gonna have to get up at 4:30 in the morning and take her down there to your mom's house, didn't you?
Okay. I mean, I did not talk about that. That wasn't asked.
Okay, so you were disingenuous with the court then, right? You more or less, and Ms. Roberts just said, you more or less just stated that, or you more or less testified, and I guess we can look back at that, but you more or less testified that this was just gonna be a straight, you're taking her to school. But that's not how it is it?
Objection, Your Honor. Exactly what the testimony was. He's taking her to school.
No.
Well, I think that Mr. Spratt is asking the question that he's arguing that the impression left with the court at the April hearing was that he would be taking the child from his home directly to school. There was no testimony about waking the child up at 4:30 in the morning, taking the child to his mom's, then going to work and then coming back at 7 a.m. to pick her up and take her to school. Of course, we were not dealing, we also, the temporary order I put down was for summer rather than work, week on, week off during the school year, but that's why we're here today. So overruling the objection, I think it's a fair question.
So you left that out in April, right?
It wasn't asked, but yeah, sure.
You were asked, okay, but it was your whole reason for a material change in circumstance in this.
Objection, assuming facts not in evidence, there's other allegations in the petition and other testimony that was not the whole reason. You said the whole reason was, the question was, your whole reason on asking or saying.
I'll rephrase it. I'll rephrase.
Objection to the form of the question is sustained.
Okay. One of your reasons for the material change in circumstance was your change in work schedule, so you could take the child to school, right?
Yes, but what I will say is that when all our separation and divorce was going through, my situation was completely different. I had no set days, no set time. There were times where I would go to school, go to work at like 2 a.m, but that was then.
Understand. I do, I understand. But what I'm saying is, you presented it to the court and you left this part out about having to wake the child up at 4:30 in the morning. In April.
Yes, that was not talked about.
Okay. Those are my questions.
Anything further? Thank you, Mr. Coleman. You may step down.
That's our real.
Plaintiff is, petitioner is resting his proof on this, issue before the court. Do you have any proof you wish to offer in addition to what's been heard?
We have no proof, John.
All right, do you wish to be heard in argument?
Yes, Your Honor. And again, what we're asking for is shown week to week. There's week to week all year round. There's been no testimony offered in this court that would say that they cannot do that. Albeit my client has testified that his work schedule is such that the child has to get up, but there's no testimony to show that that's adversely affecting the child. The child gets up, goes to his mother's, lays back down, goes to sleep. He picks her up and carries her to school. He's off at 3 o'clock. He has the whole afternoon of that. Mrs. Gadd on the other side, again, she has to be at work at 8 o'clock in the morning. She's working overtime. She's working weekends. That's what her testimony has been. And that when is she dropping the child off? When is she picking the child up? Who's doing the aftercare with the child during her week? Again, Mrs. Gadd comes in. We know that the order specifically said you reserve the issue of child support. She comes in here without any indication of what her income is. She did not submit it the last time. Again, the issue being is that she was supposedly going to get into PA school and she has not done that. She hasn't even applied at this point in time. Apparently she's just graduated as of today with her degree and hasn't applied. The testimony before is that there was an indication to change the residential schedule. My client is ready, willing, and able to take care of the child. It has the availability to do that on a week-to-week basis, and we respectfully ask that Your Honor grant that. And Your Honor, we would say since her income, I haven't done the numbers, if she's making, and again, the problem being her testimony was, if she makes $16.50 an hour for her 40 hours, usually a full-time job, but she makes 25% addition if she works on weekends. So again, Your Honor, I think the appropriate matter, if you even just take, of course, the child support guidelines say if they do not come in and have income information, then Your Honor is well within the guidelines to impute income to her. And so, if I did it right, if she's making $16.50 an hour times 40 hours a week, that's 660 times 52. That's 34,320. That's below the amount that is standard in the child support guidelines to impute. And I believe it's some 36,000 for a female in the state of Tennessee, and we would actually use the imputed income.
Brett?
Your Honor, throughout the trial and throughout today's hearing, we've heard a lot about Ms. Gadd trying to better herself, and Mr. Coleman wants to use that against her. And regardless of the way I phrased the question earlier, I believe the court's first notation on a material change in circumstance was based on his change in job. I can't obviously say that was the only change, and I rephrased the question there, but the court didn't have all the facts there. So the child who, by all accounts, both parties agree that the child has flourished in Lakeview School. But I don't know that we need testimony to arrive at the conclusion that waking up a child at 4:30 and taking her across from Benton County all the way to Waverly and then back to New Johnsonville is just a disruption that the child doesn't need. The court's ruled that there's reason to modify the residential schedule, and at this point, that ruling is res judicata. But I think what we would say is that the residential schedule that the court had, where it was extended weekends every other weekend with the holidays split, would be appropriate. So somewhere in the neighborhood of what they were doing prior to the summer. Just based on the school year, and that alone, I think, would be enough for the court not to go week to week on this case. As far as the income goes, I mean, she's testified that she does make that 25% an hour, and her not bringing her income in here, that's my fault. If I need to get an income statement in here or something like that, or get Ms. Robert a paycheck or something like that, we can do that. And I think we could probably do that and come up with the child support amount based on the court's ruling as far as the residential schedule goes. But we'd ask the court to set some schedule where Mr. Coleman gets extended weekends every other weekend. Again, uprooting the child at 4:30 in the morning once every couple of weeks is not anywhere near as disruptive as trying to do that every other week. That's a different sleep schedule one week for the next week. So a child that's flourishing, I don't see the need to disrupt that schedule, Your Honor.
Well, I'm gonna take a break and I will review my notes and give this matter some thought, and I'll come back and give you my ruling.
All rise.
All right, this case, as we have talked about already, appeared before me on April of this year. And at that time, the court made certain specific findings regarding the material change of circumstances that were alleged to have occurred in this case. And I made certain findings, and those are set forth in the order. Among those is the fact that there was not a sufficient finding of material change of circumstances to meet the higher burden for the change of primary residential parent. That instead, I did find that there was a material change of circumstances that would justify a modification of the residential schedule, and I made such modifications. The original parenting plan provided that Mr. Coleman would have every other weekend from Friday at 6. Well, first of all, the designation of the mother, Miss Gadd, was the primary residential parent. Mr. Coleman, as the father, was then given every other weekend from Friday at 6 to Sunday at 6, and then they alternated the major holidays and alternated the school breaks. He got 2 weeks of summer visitation, non-consecutive weeks of summer visitation, if I recall correctly, in that original parenting plan. So I made finding that there was evidence to substantiate a change of material change of circumstances as to the parenting schedule. And I made those findings and set them forth in the order. However, I did reserve the issue, and one of the changes I made was that the summer visitation schedule was to be alternating weeks rather than only 2 weeks. I did so in order to give a kind of a trial run for how things were going to go. And today, what I hear is that at the first hearing, perhaps I misunderstood, and perhaps it was my fault rather than the party's fault. At the first hearing, I certainly had the impression that Mrs. Gadd and her husband were living together and that there were no issues. I made that specific finding. Whether that question was specifically asked or not, clearly that was not in fact the case, that was not the circumstances that existed in April. Now, this incident occurred in May after that hearing. So, and if he has been eliminated from your life and will no longer be a factor, then it really is not a significant issue, but it is one that causes me some concern that the impression that I was left with was clearly that you and he were together and that there were no issues. And I found that as a finding of fact. It was also my impression that Mr. Coleman, in his testimony presented to the court, that he had the flexibility to, with his employment, that he would have the ability to modify his employment to provide for his daughter if he was given some additional time and these alternating weeks and so forth. I relied upon that in giving him the opportunity during the summer to have the alternating weeks. Unfortunately, today, what I hear is that Mr. Coleman's idea of modification of his work schedule is to allow him to go to work at 5 o'clock instead of perhaps 1 or 2 o'clock in the morning. Getting a child up at 4:30 in the morning at this age of 7 years of age and taking that child to another location, expecting that child is then going to go back to sleep somehow and then come back home and take that child to school is, in this court's opinion, based upon my own personal experience with both children and grandchildren, somewhat unrealistic. If you has been able to, Mr. Coleman, modify your schedule where you could take the child directly from your home to school, that's one thing, and not have to get the child up at 4:30 in the morning. The most important thing that I hear from my own experience with my children and my grandchildren and from my reading, educational experts will tell you the one most important thing is that a child needs to get adequate rest to be able to pay attention and to function properly in school. So I am just of the opinion that the 4:30 in the morning on a school morning is a very dicey proposition for the child such as this. 366106 of the Tennessee Code sets forth the following, subsection A. In a suit for annulment, divorce, separate maintenance, or in any other proceeding requiring the court to make a custody determination regarding a minor child, the determination shall be made on the basis of the best interest of the child. In taking into account the child's best interest, the court shall order a custody arrangement that permits both parents to enjoy the maximum participation possible in the life of the child, consistent with the factors set out in the subsection A, the location of the residence of the parents, the child's need for stability, and all other relevant factors. The court shall consider all relevant factors, including the following where applicable. And then it sets forth the list of custody factors, which the court always has to look at and did look at in the original findings. So I am now faced with trying to determine how to maximize Mr. Coleman, who I believe to be a very good and caring parent who wants to be a part of his daughter's life, who works from early in the morning till mid-afternoon and gets off at 3 o'clock in the afternoon, if not earlier, and balance his ability to be a part of his daughter's life with that of the mother, who works right now 8 to 5, and we are told is likely to be involved in, if she's enrolled in school, is going to be a full-time student and so forth. There was no testimony today about what childcare arrangements are made when the child is with the mother and she's at work full-time. So to maximize the participation in the life of the child with Mr. Coleman, the court makes the following findings. As I've previously affirmed, the mother shall remain the primary residential parent. Mr. Coleman shall have every other weekend from Friday at 6 to Sunday at 6. In addition, Mr. Coleman shall have the right to pick the child up after school every day and take the child to his mother's, if that's what he wants to do, since she lives in Waverly, and provide care for this child until 6 o'clock, when the child shall be returned to the mother, and she'll be home from work, and then she can engage in the normal routines for the school. I do that to give you your child every day. You're going to get to see her every day during the week. On Fridays, you'll pick her up after school and you'll take her home with you and keep her until Sunday night. And then Monday morning or Monday afternoon, you'll pick her up again. I'm depending on you to ensure that, and this will be a part of the court order, you'll be responsible for making sure that she gets her homework done during that time. I don't know in a second grade, which is what I think she's going to be in, that she's going to have a lot of homework right now. A lot of my grandchildren don't have that much homework, but you're going to get to be a part of her life every day. You're going to get to be a part of her life every day. Normally, this would be a little bit too unstable, but under the circumstances, somebody's got to provide care for her while she's at work. It might as well be you. And I think you're a good father, and I think you deserve to have that opportunity. So what I'm doing is I'm giving you every afternoon from after school. You pick her up at school. You take her to wherever you don't have to take her to your mother's, but I'm going to assume you're going to probably want to take her to your mother's since she's there in Waverly, and you let her get stable. You're telling me you can be done every day by 3. So if you have to go to work at 1 o'clock in the morning to be off in time to pick your daughter up, that's up to you. But I'm ordering that you do it. This also eliminates a cost of daycare, after school daycare, if there is one, that was going to be applicable as well. She's got things she's got to attend to that are going to require her to be there from 8 to 5, school or work, either one, or clinicals, whatever that may be, she'll have that. And you're going to have to provide care for her after your daughter's out. All other aspects of the original father's proposed parenting plan, which is just modified. The only thing modified in the parenting plan the father proposed is that he have primary custody and the mother, and that's ironic. I will touch on this when I go back and I look at this file. What he filed in his original petition to modify was that he be the primary residential parent, that she get every other weekend and 2 weeks during, and alternate the weeks during the summer and alternate the major holiday. What she filed was that she be the primary residential parent and he get every other weekend. So both of them thought, you know, what the other one ought to get is just every other weekend. So it's a little ironic that I didn't have to make this decision, but what I'm trying to do is to balance the equities to give you an opportunity to maximize your participation in your daughter's life. I don't think this, and I say this for the record, I am going to continue the alternating weeks during the summer because that's part of the court's opinion that in almost every case, non-custodial parents ought to have alternating weeks during the summer. And that alternating week for you will begin the week, the first week after school is discharged will be with the mom. You'll alternate weeks, and then the first week back before school starts will be with the mom so that she can deal with getting the child enrolled and everything all like that. But otherwise, you alternate every week during the summer. And during the summer, this picking the child up from school obviously doesn't apply. It'll be her responsibility. That's different than the school year. The school year is what I'm dealing with today. But he will be responsible for taking care of making sure that the child is getting all the homework done and things like this. If there's a problem that arises from that, then we'll have to deal with it down the road. But by doing this, it gives you an opportunity to be there so that you don't have to worry about these FaceTime calls. You can still do it if you want to, but you're going to be with her for a couple of hours every day. So if you feel the need to call her, that's fine, but it also eliminates that idea that you're somehow telling her how much you miss her. But if during the summer, there are phone calls, one of the things that I can tell you is that a child misses both of his parents, in my opinion. And even though you may not think it affects your child, you're letting your child know how much you love her and how much you miss her. That just creates more emotional reaction to your child. So the best thing I can give you advice, and I'm not saying I'm the world's greatest expert, is if your child says, "Mommy, I miss you," say, "I miss you too, honey. See you soon." Something like that. Don't say only 3 more days and you'll be coming home to me, or those kinds of things. So everything else remains the same. The child support will be calculated, and this will not, unfortunately, it'll give him a break for the summer days. You'll have to calculate the number of days, but since those are not overnights I'm giving you every afternoon, it won't count towards the child support calculation. But I do find that the most appropriate way to handle this would be for each of them. His income was produced in an income and expense statement.
$5,600 a month.
Is how much?
5,600, I believe is what I.
That's 5,200. Yeah, 5,600 is what that is.
Gross.
And I do find that her income was shown to be 34,320 based on the proof. But I'm going to require that she produce a current paycheck stub to ensure what her accurate income is. I'm not going to impute income to her based on that, because I think as Mr. Spratt said, he might have been a little bit deficient in producing that. So I'm not going to punish his client for that reason. But I want that to be done within the next 5 days so that we can get this child support calculated. If there is a modification upward or downward, it'll be retroactive to the date of the filing of this petition. So,
May I ask 2 questions?
yes, ma'am.
Number 1, what her income would have been. Do I have to take the year to date, because again, before she was only working, when she testified in April, she was only working part-time. May I just calculate if it's, she says she has the capability of working between 30 and 44 hours with a 25% on the thing. So if I take the year to date, it's going to include part-time work. So.
Well, I'm going to set her current income as being the $34,320, which is what we calculated it based upon the averages and so forth. I'm going to allow the income proof for the prior time to be based on what she actually earned.
And then this has come up in 3 cases this year that I have had when Your Honor has ruled that again.
So 3 cases I've ruled that I've done something wrong.
Well, it's never come up. It's come up 3 times this year, and I haven't really had to deal with it in the past. Your Honor customarily will put the child back the week before school starts with the primary residential parents, so you can get all of the stuff done and all that stuff. Well, schools, I guess we show our age because we're thinking that school's starting on Monday, so it's really easy to define the week before. Now, like Dixon County started on Thursday this week. So the one issue that I had was.
I'll show you a picture of my granddaughter's first day of school.
And I saw it on your daughter's Facebook page. So so the issue being is last week was the Father's Week. This week was the Mother's Week, and the child started school on Thursday. So in the case I had, the mother decided she got the week before school start. So she took the father's last week from Friday until Friday, then hers started Friday until this Friday. So she effectively got 2 weeks before. So is a week defined 7 days before school starts, or do you get the whole week even if school doesn't start on Monday? That makes sense?
You will both obtain a copy of the Humphreys County where this child goes, the Humphreys County school year for the 24-25 school year and 25-26 school year. When does the school start?
Started yesterday.
Started yesterday. So
They started on Thursday, just like Dixon did.
all right. If the school year starts in the middle of a week,
Wednesday or later.
then the mother's week, she will get the week that the child goes to school in. So she'll start, we'll exchange on Fridays
Right.
for this like we've done before. And she'll get the child on the Friday before the following week when the child starts school. And that'll be how it's defined.
That's what I thought it was, but I've had it because my client's on the losing end and the other attorney interprets it as it's the full week before. So my client goes 14 days without seeing the child, and then next week and so I thought it was, I just needed to clarify in my own mind.
What we need to do is just make that a standard. If it's my ruling, then I make that ruling, then we need to make sure that that's stated in court, and I'm sure that you'll remind me about that, but
I will try my best.
I will need to make sure that is part of the applicable ruling. Mr. Spratt, what do you have?
Judge, can I have 2 weeks to get that income? I've got a first degree murder trial starting Monday.
You need to what?
I need 2 weeks if I can to get her income, Ms. Roberts. I have a first degree homicide trial with Judge Wallace starting Monday.
Well, that's no big deal.
Nah.
Yes, you may have 2 weeks to get that income.
And I would, Mr. Spratt by his law partner, got hoodooed into this from some manipulative,
The
things.
murder trial or this case?
And Mr. Flanagan withdrew from a case in a murder trial and got it continued, and then thought that he might be able to get rehired and get back in it. And when the Judge Wallace said, no, you're out, then Mr. Spratt got enlisted by his law partner to assist him in this case. So I don't have a problem with him having 2 weeks because he's already been put upon by.
Did you get hired?
I did, Your Honor. Mr. Flanagan's got some culpability in this as well. So if Mr. Baker's watching, he's definitely culpable. But I give Mr. Flanagan plenty of blame.
Well,
He's now a jury consultant.
in any event, we'll give you 2 weeks to get that income. It shouldn't be that difficult to get that income information, but we set the current income, so we know what the current child support should be calculated without any problem. So it's really just a question on the remaining issue about what any sort of modification post. All right. Anything else?
No, Your Honor, I'll submit the order to Mr. Spratt and we'll submit it to Your Honor for approval.
Ms. Gadd and Mr. Coleman, you are both, I think you're lucky to have a daughter that loves you both, and I think you both love your daughter. I've seen a lot of fathers come before me who don't really care about the best interest of their child. What I've done today is to try to balance what I see as a very strong desire on your part to be a part of your daughter's life and to be there for her with the best interest of your child as I see it in her educational needs. And I think it is very important for her to do that. And as I said, I base that upon not only what I read, but also what I've talked to other educators about and what I've experienced firsthand. When you get a child up at 4:30 in the morning, the child's not functioning properly when you get later in the day. So children need to be awake and alert when they go to school so they can learn as much as possible. And I know that it's not likely to do any good, but both of you need to remember that your daughter's interests ought to come first. And if you'll put your daughter's best interest first and every decision that you make regarding her. And if she's going to be off from work one day early and wants to pick your daughter up, then let her do it. I mean, she misses out on a lot of those afternoons because of her work. Your work's different. But if you will do that and give her that opportunity to experience and be there in the afternoons, then I think you'll find that she's more willing to cooperate with you in some modification. You can always try to work together, but if you don't, then your daughter's going to pick up pretty quickly, if she's as bright as I think she probably is, on the animosity that exists between the two of you. And she will know that mommy and daddy don't get along, and that will affect her for the rest of her life. So hopefully you two can learn from your own problems and get past that. You've made obviously a decision to end your marriage to this gentleman, and I applaud you for that if he did what he did. So now you have the father in the situation, and you two can co-parent together without any kind of interference. And I hope you will do that.